Ladies and gentlemen, it's my pleasure and honor to introduce my good friend, Professor Ingo Sarlet, from the PUC of uh, PUC is the Pontifícia University, Catholic University, that comes from Rio Grande do Sul. Is a wonderful fellow, is a professor, a well-known professor in Brazil and in Europe, all over the world. He teaches mainly constitutional law and environmental law. These are his two main passions, and he's going to talk about this uh, um, because the topic he chose has to do with climate change and its consequences for the world of war. So, without further ado, I'll give the floor to Professor Ingo Sarlet for an introduction, a conference, let us say, and then we'll have some possibilities of discussion. I have to excuse me because I have problems with my camera that I cannot solve. It happened already. Now I think the image even disappeared. In the beginning, there was an image, but I'm listening and I'm seeing you, so I'm in conditions to be. It's just not very pleasant, not appearing, especially for me, but nevertheless, I'm here. So, Ingo, thank you very much for being here. I forgot to say that you are an LP scholar, is a member of our group, the LP's group, and this conference is integrated in the transnational lecture. They are a part of our joint master in the Alps. Ingo, you have the floor.
Okay. Well, first of all, I want to greet everyone and thank the coordination of this amazing cycle of lectures for this opportunity in the name of my dear colleague and friend, Professor Vasco Pereira da Silva, and also Professor Klaas Friedrich Germelmann, which is also one of the organizers, so far as I know, from this cycle of lectures. I also apologize for not being really fluent in English and for reading my presentation. That's not common. Usually when I talk in Portuguese, I speak freely. The title, Climate Change, Human and Fundamental Rights and the Role of the Courts, is quite ambitious for such a brief intervention. That's why I'm focusing, after presenting some general remarks, on the case of Brazil, where the role played by courts in terms of environmental protection is gaining day by day more importance, including the so-called climate litigation. Besides this, it's also well known that Brazil is one of the most important countries in the world in which, in regards to the diversity and magnitude of its biodiversity and its role as one of the lungs of our planet. That's why problems in Brazil are also problems in the whole world, in this matter. In Brazil, it's also important to mention, before starting with the case of Brazil, that the seriousness of the climate issues and its consequences, as is well known, is of such magnitude that some countries have decreed a state of climate emergency, as, for example, happened in the European Union through the European Parliament in 2019, and even in Portugal, in the Portuguese law about the national politics on climate change. In Brazil, there are also claims to this effect, including in lawsuits before the Supreme Court, and a state of climate emergency was even recognized in one important case, our first climate case decided in 2022. This scenario of damages already caused and of serious risk to human life and to the biotic and abiotic environment, as well as to human dignity and human and fundamental rights, has given rise to an important discussion, both in the constitutional sphere and in international law, about the recognition of a human and fundamental right to a clean, healthy, and safe climate, a core expression of the right to a healthy and balanced environment. From this perspective, the current ecological rule of law, which is also a democratic and social state necessarily incorporates a climate dimension as well, not least in order to safeguard fundamental rights from a transgenerational and intertemporal perspective, taking into account the interests and rights of future generation. In this sense, it is worth mentioning as an illustration the case of Neubauer et al. Versus Germany, judged by the Federal Constitutional Court of Germany, Bundesverfassungsgericht, in April 2021, when the courts have spoken from an intertemporale Freiheitssicherung. In addition, the subject is part of a context that is necessarily marked by intense dialogue between legal orders, as well as the growing relevance of what has been called a dialogue between courts, in addition to the multi-level perspective that characterizes the interaction between international law at a universal and regional level and the domestic law of states. Perhaps, as has already been suggested by my friend Vasco Pereira da Silva, for the constitutional and administrative law, it is possible to speak of an environmental and climate law without borders. I hope I'm right, Vasco.
Yeah.
In this sense, the integrity of the climate system is identified as a common interest of humanity and expressly referred to in the preamble to the Paris Agreement from 2015. On the other hand, the omnipresence of environmental and climate issues demonstrates how seriously the interdependence and indivisibility of human and fundamental rights of all dimensions, civil, political, economical, social, cultural, and environmental, must be taken, given that their enjoyment is impacted by and even depends on a healthy and balanced environment and a healthy and safe climate conditions. From this perspective, it would even be possible to speak not only of a preferential position for environmental and climate protection in the sense of a in dubio pro natura, but also of a kind of a right to have effective rights. If in her time and context, Hannah Arendt talked about the nationality as a right to have rights, nowadays the urgence of environmental and climate protection, along with all other related problems and challenges, allow us to speak that the human and fundamental right to a healthy environment and a safe climate has, if not replaced, at least complemented the brilliant idea from Hannah Arendt. In this sense, it's also worth mentioning a statement from Michel Klöpfer, an important public and environmental lawyer from Germany, a former professor from the Humboldt University, Berlin, that even the traditional conception of the three core elements of the modern state, sovereignty, people, and territory, must be reshaped and complemented by a fourth element, namely the environment. These considerations are also supported by a series of international documents. In the Inter-American Regional System for the Protection of Human Rights, the Advisory Opinion 23 from 2017 on Environment and Human Rights of the Inter-American Court pointed out the link between environmental protection, climate change, and the realization of other human rights. In addition, the Inter-American Commission emphasized that several fundamental rights require a minimum environmental quality as a necessary precondition for the exercise. Also in this context, the UN General Assembly, through Resolution A76 from 2022, recognized the human right to a clean, healthy, and sustainable environment and stated that I'm quoting here, that environmental degradation, climate change, biodiversity loss, desertification, unsustainable development constitute some of the most urgent and serious threats to the ability of present and future generations to ethically enjoy all human rights. The same approach underlines the important decision from the Inter-American Court for Human Rights in the case Inhabitants of La Oroya versus Peru, but mainly in the also recent advisory opinion on climate change and international law 2024 from the International Tribunal on the Law of the Sea, the consultative opinion 32 from this year from the Inter-American Court of Human Rights, and the more recent advisory opinion on the state duties in relation to climate change from the International Court of Justice. Against this backdrop, in parallel with the regulatory advances at international and national level, the climate issue gradually began to occupy the judicial agenda in an increasing pace, including reaching the courts, with emphasis here on the Supreme Courts and constitutional courts, and even international courts, as is the case of the important case Verein Klimasenioren in Schweiz versus Switzerland, judged by the European Court of Human Rights in 2024. Just to have an idea, according to data from the Sabin Center for Climate Change from the Columbia University, New York, in the whole world, we have nowadays 4,280 climate litigation cases. The 5 countries with the highest number are USA, 3,036 cases, Australia, 184, Brazil, 145, UK, 136, and Germany, 67. One important aspect to have in mind is that sometimes it is not easy to draw the line between what is able to be called a climate case and what is not. In this perspective, one can follow a common opinion that we have climate case in a strict or proper sense and case with an indirect effect on climate change issues. This reminds us of another problem to be faced, namely the discussion about the autonomy of climate change issues and law in relation to other aspects of environmental protection. In terms of fundamental rights theory and praxis, there is a question if the right to a healthy environment and the right to a safe climate have each one its own and autonomous scope of protection. Among other possible consequences of the autonomous approach, one can mention a recent case decided by the European Court of Human Rights in January this year. In the case Caravaciolo and others versus Italy, here in a nutshell, the issue at stake was a fight against massive pollution caused by many decades of illegal and uncontrolled waste disposal by private actors in the Campania region. In addition, the lack of compliance with state protection duties to prevent, control, and mitigate such practices was questioned, and they cause damage that even included risks to the lives of people living in the affected region, which is why a violation of Article 2 of the European Convention was argued, which combined with Article 4 deals precisely with the right to life. At the time of the trial, the European Court concluded that there had been a violation of the right to life and therefore of Article 2 of the Convention, considering the absence of adequate and sufficient measures by the public authorities to protect the lives of people living in this region, notably the authors of the case. In addition, the court relied on the criteria of due diligence and causality developed in its case law on Article 8 of the European Convention, the right to respect for private and family life. Furthermore, it's noteworthy that the European Court ended up drawing a distinction between the Caravaciolo and the Klimasenioren cases, admitting by a majority of 6 votes to 1 only the request made by individual applicants, in addition to distinguishing between environmental issues in the broad sense and aspects related to climate change. Considering not only the procedural issues, but mainly the substantive ones, it seems wrong to separate climate protection from environmental protection in general. Climate changes have, of course, a profound effect on environmental issues and vice versa. Of course, there are specific aspects related to climate change and the proper answers that the law can offer to face them. But this we also have with air pollution in general, water pollution, solid waste, etc. Therefore, what seems to make more sense is to recognize a kind of relative autonomy due to the need of some level of specialization. This premise points to another preliminary aspect to be underlined, namely that the general environmental principles also apply, even with some adjustments depending on the case, to climate change issues. Just to mention some of those principles: sustainability, cooperation, precautionary principle, polluter pays principle, non-retrogression, democratic participation, etc., etc. The same, of course, happens with the relationship between climate and environmental protection and other domains, like other human and fundamental rights, the social and economic order, taxation, good governance, among others. The so-called ecological, constitutional, and international order cannot be understood and interpreted as a separate island, isolated from other fields. That's why it's better to assume that when we talk about a human and fundamental right to a safe climate, we're in fact talking about an essential dimension of the right to a balanced and healthy environment and a part of the ecological minimum of existence. Having presented some general concepts and premises, it's time to focus how the relationship between human and fundamental rights, climate change, and courts has been understood and developed in Brazil. This is the second part of my presentation. I hope not being too fast while speaking. I hope being clear enough to be understood. The case of Brazil must obviously be placed in a formally presented broader context, but it has its own peculiarities, especially regarding the relatively detailed constitutionalization of the environmental agenda. The first point to note is that the Brazilian Federal Constitution from 1988 has been considered as a constitution of a democratic, social, and ecological state, which requires, even considering a preferred position of the environmental protection, a kind of transversal approach in order to achieve a sustainable development in its three basic dimensions: environmental, social, and economic. Another aspect underlined is that, unlike other countries, one even earlier example is provided by the Portuguese Constitution from 1976. Our current Constitution expressly provided for a fundamental right for everyone to the protection of an ecologically balanced environment, which is a good for the common use of the people, so the Constitution, and essential to a healthy quality of life, imposing on the public authorities and the community the duty to defend and preserve it for the present and future generations. Although this right was recognized under the heading of the social order and therefore not in the catalog of fundamental rights, in 1995, our Supreme Court equated it with a fundamental right with all the guarantees inherent in such a condition, such as in particular the immediate applicability and direct effectiveness of such a right, the direct binding of all state actors, and the fact that it is a substantive limit on the power of constitutional reform. This example shows that even before there was a talk of a climate litigation in Brazil, the judiciary, especially through the actions of its two main courts, the Superior Court of Justice and the Supreme Court, has taken a leading role in environmental protection. For those not aware of the Brazilian judicial system, while the Federal Supreme Court is based formally on the US model, also the guardian of the Constitution, the Superior Court of Justice is in general comparable with the German BGH and the Supremo Tribunal de Justiça from Portugal, just to have an idea how this court works. But differently than in USA, the Brazilian Federal Supreme Court has also strong competence, besides the classical judicial review, for the concentrated and abstract control of constitutionality. Another point to stress is that although the principles of environmental law have not been directly and expressly referred to in the constitutional text, over the years the Supreme Court has recognized them as having constitutional statute, although Brazil has ratified the respective international treaties and the inclusion of some of those principles in the infra-constitutional legislation. The main principles to be mentioned here are the sustainable development, precautionary principle, the ecological dimension of human dignity, the dignity of the nature at all, democratic participation, polluter payer, indubio pro natura, prohibition of retrogression, as well as the application in various cases of the category, very well known by the German, Portuguese scholars, legal scholars, of the prohibition of insufficient protection. These developments, as we have already pointed out, are prior to the so-called climate litigation, which, at least considering the higher courts, and especially the Supreme Court, began around 2020, 5 years ago, when the first lawsuits reached the Supreme Court. Before starting to present some of the important climate cases, there are a set of former precedents from the Brazilian Superior Court of Justice and the Federal Supreme Court to be mentioned, which paved the way for a strong level of legal protection of the environment in general and the climate in particular. besides the recognition of fundamental right, as we have already seen, and the constitutional rank of all environmental principles, even the majority not being expressively previewed in the constitutional text, some other achievements are worth mentioning. That's not the mandatory order. No? First, the development of a strong regime of civil environmental liability, strengthening the legal concept of environment, pollution, and polluter, including the so-called indirect polluter. Just to mention a concrete case, we have now 3 cases, important cases, not climate cases, but environmental cases in London before a high court, the Mariana case, disaster case against BHP, UK and Australia, the Brumadinho beach disaster in Munich, Germany, against TÜV Süd AG, and a case from Maceió against Braskem subsidiaries in Holland, in Rotterdam. I had the honor to be a legal expert in all of these 3 cases, defending, in my opinion, the right side vascular, the victims in this case. A second important achievement is the reversal of the burden of proof in environmental claims, at least as a rule. The joint liability of all polluters, the absence of limitation in case of collective environmental damages, the horizontal effect of the right to a healthy environment and other constitutional provisions related with the protection of the environment and the climate. The fact that the catalogue of constitutional environmental duties and of protection is an open one, which includes the possibility to recognize others and even implicit climate duties of protection already recognized by our Supreme Court and Superior Tribunal de Justiça. The fact that all duties of protection are binding and must be fulfilled by all state actors, and 8, the consideration in several cases that environmental and climate protection must be seen in a broader context, especially when it comes to take care of the rights and interests of socially vulnerable groups like indigenous people, traditional communities, for instance, fishermen, and Afro-Brazilians. And finally, the recognition that international environmental treaties, although not being typical human rights treaties, should have the same legal rank than international human rights treaties, which means that they prevail about all domestic legislation being submitted only to the federal constitution. Having had a broader overview, let's start in the last part with a short presentation of 4 important cases. We have much more, in order to illustrate how climate litigation is step by step, but fastly evolving in Brazil. The first 2 cases judges were the so-called Climate Fund case and the Amazon Fund case, both in 2022. In both cases, it is important to emphasize the recognition of state climate protection duties, for example, mitigation duties and adaptation duties. In the Climate Fund case, the Supreme Court recognized that the constitutional illegitimacy of suspending the use of resources from this National Climate Change Fund, which was created by law and receives national foreign resources, especially from Norway and Germany, to combat the deforestation in the Amazon region. In general terms, the Supreme Court decided that the executive branch has the duty to make the Climate Fund work and allocate its resources annually with no contingency due to the constitutional duty to protect the environment and international commitments made by Brazil. In addition, the decision consolidates and strengthens the jurisprudential orientation already seen in other Supreme Court rulings by using a dialogue with the recent case law of the Inter-American Court of Human Rights in environmental matters, and of course, the supralegal hierarchy of environmental treaties. In this case, the Framework Convention on Climate Change from 1992, the Framework Convention on Biodiversity, and the Paris Agreement were placed above all Brazilian infra-constitutional legislation. In its judgment on the Amazon Fund case, the second case, the Supreme Court ordered the federal government to adopt within 60 days all administrative measures necessary to reactivate the Amazon Fund without further paralyzation. These cases were at the time of the last federal government, Bolsonaro, which suspended the application of these funds as well as other measures to reduce strongly environmental protection. The majority of the justices concluded that the decrees that already altered the fund's format and prevented the financing of new projects were unconstitutional, and also ruled that the previous model should be reassumed. The court ruled as well that the changes made to the fund's format since 2019, with the unilateral extinction of committees and without the creation of another administrative body, prevented the financing of new projects, which constitutes an omission by the government in its duty to preserve the Amazon region. In 2024, the same understanding, another case, was reinforced in the judgment of another emblematic case, with emphasis on the following passage by one of the justices, the reporter, when he expressly recognized in his vote the recognition of fundamental environmental, ecological, and climate rights and duties. The plenary unanimously ordered the federal government to take steps within the scope of the action plan for the prevention and control of deforestation in the legal Amazon and other programs to reduce deforestation in the legal Amazon to a rate of 3.9 kilometers per year by 2027 and to 0 by 2030. We know that's impossible. It's impossible to prevent at all 100% deforestation, but we already have had a strong reduction in the last years during the Lula presidency. We have really increasing reduction in deforestation, which of course very important for all of us. The court also ordered the National Congress to open an extraordinary credit in the 2024 financial year to ensure the continuity of government actions and to notify all legislative houses of the decision. It also prohibited the budgetary blocking of resources for programs to combat deforestation. By a majority, however, the plenary denied, that's interesting, to recognize a massive violation of fundamental rights and therefore an unconstitutional state of affairs in Brazilian environmental policy. This was because the court recognized that although it has not yet been concluded, a process has been underway since last year for the Brazilian state to reassume the effective exercise of its constitutional duty to protect the Amazon biome. The issue of forest fires, which is directly linked to deforestation and climate change, has also been the subject of several lawsuits before the Supreme Court. There are at least four filed in 2020 by political parties, including our party network of sustainability. And these constitutional actions demanded that a governance plan should be drawn to protect the Amazon and the Pantanal region due to the fires that were raging in these biomes at this time. But not only at this time, still this year and last year, we had really huge fires in these regions. On 20 March 2024, our Supreme Court upheld the request made in the aforementioned actions, ordering the federal government, among other measures, to present within 90 days a plan to prevent and combat fires in the Pantanal and the Amazon that includes effective and concrete measures to control or mitigate the fires that already occurred and to prevent further devastation of this scale, as well as a plan to recover the operational capacity of the national system for preventing and combating forest fires. In view of the above, it is possible to realize from the examples how much the Supreme Court has been called upon to act to protect the environment and the climate system, especially by intervening in the sphere of action or mission of the executive branch, even that in the case of the funds mentioned, they were created by law, and there was not even any question of controlling the constitutionality of legislative act. This was practically an omission from the executive power. Another important point is that even in climate litigation, the adoption of decisions of structuring nature is gaining importance. This involves not only looking to the past, but also looking to the future, particularly in terms of seeking a solution obtained through constant interinstitutional dialogue with the various players involved. It is not a static process, but a dynamic and forward-looking one. There is a need for progressive conformation of behavior, for example, on the part of government bodies, in order to ensure due and effective compliance with the Supreme Court's decision. Moreover, the peculiar nature of the Supreme Court structural decisions reveals precisely this future and even prognostic perspective, which means that in the factual scenario changes, new measures not only can but must be adopted in order to ensure effective compliance with the decisions handed down by the court. As an illustration, the Supreme Court created a Center for Complex Structural Processes to help to conduct this process and to monitor its implementation. From a constitutional point of view, judicial control of public policies, environmental and climate matters is fully legitimate in a scenario of omission or deficient or insufficient action by the legislative and executive branches, as the Supreme Court has already ruled in environment reduces the sphere of discretion state protection and the prohibition of retrogression. The administrator's inertia or insufficient action represents a violation of the Constitution, authorizing judicial intervention. This is a statement from the court itself. In view of all the above, it's possible to state that the Superior Court of Justice and the Federal Supreme Court have been exercising a relevant role protecting the environment without entering in an illegitimate way the sphere of action of other state powers, which continue to have, of course, the priority with regard to the creation and execution of public policies. The judiciary, taking the liberty of invoking a figure of speech, is in fact exercising the function of a kind of firefighter, making a significant contribution to the process of fighting fires and other environmental and climate disasters that have plagued Brazil. The possibility of fighting climate change through courts has also a participatory and democratic element in the sense of a procedural active citizenship, including civil society in this process. This we can see through the number of public hearings organized by the court, with participation of other public bodies, experts, scientists, and so on, and with possibly for amici curiae briefs, which are very common before the Brazilian Supreme Court. On the other hand, we shouldn't overestimate the role played by courts, which cannot replace the politics and a scheme of shared responsibility between state and civil society. This is something we're still trying to achieve in Brazil. In this sense, it's also important to remind us of the lessons from one of the most prominent constitutional law scholars of all times, also friend of Vasco and probably some other colleagues here, namely Professor Peter Häbli, who has recently passed away, but we all know, who, along with so many other regional and influential achievements, wrote about the recognition of a status activus processualis, a kind of an active procedural citizenship and the need of an open society of constitutional interpreters. In other words, without a multi-level, transnational, cooperative, and participatory approach, it will be very difficult to fight climate change and assure a healthy future for all human beings and for our planet. Differently than a couple of decades ago, nowadays this is not anymore only a question to prevent a decent life for future generations. It is also a question of our own way of living on Earth. And we all should know, sorry, that even the most selfish human being that deny this evidence is, at the end of the day, a denial of our chance to have a future in which it is still worth living. I thank you for the attention. I hope being understood. Thank you so much.
Thank you very much. It was indeed a wonderful lecture. And I ask the audience if there is any question. David, please go ahead.
Hello.
The emission is not in the best conditions, but we can hear. That's the most important, and see us. So.
Thank you very much, Professor Da Silva and Professor Gemmelmann, for organizing this, and thank you very much, Professor Sarlet, for this talk. Just two questions that I have. You mentioned some cases in which you were involved, so I want to know the following. What is the political environment around these cases? When you work as a lawyer in such cases, do you feel that like it has some political connotation and political aspect when you are engaged in such cases? Because I can imagine that maybe the other side is represented, like the other side is big companies and maybe big economic interests are at stake. And the second question is the following. In those cases that you mentioned, or in similar cases, do we normally have also the aspect of monetary compensation for the clients? Thank you very much.
Okay, let's thank you so much, David. I will, of course, start with the first question. Yes, the answer is yes. This is something different. This is different in two of the cases. The pressure is quite lower than in the biggest case in London, the Mariana mining and dam breach case. Of course, we had political pressure in all cases in Brazil, but at international level, the most, let's say, impacting case is the Mariana case before a high court in London, and they announced a judgment for tomorrow morning in England. So that's in the last news they have. But here we have a really big pressure. We have a campaign, a really open campaign against the lawyers, which are, of course, running the case. I'm not the lawyer. I'm a legal expert. I write opinions and give evidence before the court as a legal expert. No? And here the pressure is big. Even in our Supreme Court, BHB financed an institution in Brazil to file a case before the Supreme Court to try to stop municipalities to claim in London abroad, saying that it's against the Brazilian sovereignty, a campaign against the lawyers, a campaign against crowdfunding, and so on. When everyone knows that the costs of a case in England are very, very high, as hundreds of millions is the cost of a case, because they are, in terms of euros, about 40 billion euros at stake, and about 700,000 victims are in the case, are trying to get compensation at international level. So, of course, there is political pressure in news, writings against this, and so on. Even some writings saying that these are, let's say, ambitious and even kind of with lack of bona fide claims. They are trying to put them as victims, no? And so on, so on. We had cases in Brazil as well, okay? So we have cases in Brazil in all these three situations, and we have these cases in other countries. But the difference is that, of course, in Brazil, the Brazilian companies are being sued, and of course the subsidiary companies from the companies in England, Germany, and that is not in business eating, because these companies are not the same payers than the companies abroad. And that there we had a big agreement, but in order to pay in 10 years, much lower compensation than they trying to get abroad, and so on. Of course, we have details, but I must say, of course, there is a lot of pressure, and even pressure to change the law in Brazil, especially in the new project for a new civil code, the reform of a civil code. They of course, this is still a project. They have a provision excluding what we call the full risk theory from the laws. And in environmental issues, we adopted in Brazil the full risk theory, which excludes the possibility for who is called to responsibility to invoke the hand of God, force majeure, and other exclusions of responsibility. And of course, if you change this, you will have a big limitation to hold companies, especially abroad, liable for such disasters and so on. This is, of course, what happened in Brazil. I hope that this will not happen, but the pressure is very high. It's very high. The second question I forgot. Sorry, if you can repeat, please.
Yeah, basically, you mentioned already some aspects. The second question was whether in these cases and similar cases, there is some monetary compensation at stake.
Yeah, I told you, it's monetary compensation at stake because the losses were very high. No? We have material damages and personal damages a lot. We have in Brumadinho hundreds of people dead. In Mariana, of course, we had, I think, 19, 20 people dead, a little bit more people. We had the loss of houses, of business, of property, health, huge health for thousands of people, and so on. And in Brazil, we have another specificity, because in Brazil, we have even moral collective damages. So then you have to have moral individual damages, and you have moral collective damages, and you have let's say collective environmental damages and the individual private damages, so that the individuals and the plaintiffs as individuals, even legal persons, they of course have the right to compensation of their specific damages. But besides this, there are collective damages, and this compensation goes not to individual claimants, but goes to a national fund. In order, with this money of this fund, to have policies to prevent disasters and so on. No? So I think it's important to mention that we have these two levels of compensation: moral, material, collective, and private damages. I hope I haven't explained your question.
Sorry, which court was that in London?
It's a high court. It's a high court specialized in intellectual property and commercial law, private law.
Well, any more questions? Let me ask you about the meeting of the United Nations that is happening in Belém. You have any news in Brazil that we are not knowing about all over the world? Not yet.
Sorry, Vasco, do you have a little bit echo?
Yes, but I don't know how to solve it. It's
I think Nuno Guimarães has his hand raised.
Okay. No. Go ahead.
Thank you, professors. Am I audible?
Yes.
Yes. Okay. I think just a technical thing. I think Professor Vasco has 2 sessions in this meeting. Maybe that's the reason.
Okay. Should I leave? I'll try to leave with one and see if I can stay. But now you disappeared completely, and
but your sound
is fine. We can hear you clearly now.
Okay, yes. So and you hear better. It's better for the others. Okay, so let's stay like this.
My question was a doubt I have. Thank you very much for the presentation. And I was looking, I apologize, but I was looking while you were speaking to this global climate litigation database that represents more or less the numbers of cases that you mentioned before. Hello?
This is from the Sabin Center located at Columbia University.
Yeah, it seems like But my question is, there is a huge discrepancy in the levels of litigation among the countries, right?
Yes.
And what are the factors for that? I mean, is access to courts, laws on private enforcement? What makes it so different? Do you have an idea? It's just a...
No, I think we don't have really proper information about this, but we have, of course, some reasons. They are quite plausible. Access to justice is not exactly the reason, but one reason is the classification on what is climate case and what is not a typical climate case, and this can vary a lot. And of course, this depends on the country and the court giving this information, if it considers the case a climate case or not. And there's, of course, that's why I say it's difficult to draw the line, an exact line between what is a typical climate change. Another factor is that in US was the birth country of climate litigation. We have some climate litigation 20, 30 years ago, even in US. Of course, in the last years, it explodes. I think this is one of the reasons. Another reason can be access to courts, but there is another problem. In Brazil, for instance, we have a general access to court. We have a really huge possibility to claim without paying nothing. You have class actions where the public ministry can file class actions representing population without costs for the population. What happens, of course, that we have thousands and thousands of cases in the ordinary jurisdiction. And this is very difficult to classify and identify to get this data. Now we have an effort to have a better database especially for this kind of cases. No? So these cases are much more the bigger cases that are mentioned here. No? But I think, of course, it's difficult. I can give you an answer. I can talk a little bit of my country. I can try to explain why US has more cases, because they have a older, let's say, an older tradition in terms of climate litigation. And of course, it's difficult to draw the line. It depends how each court and each country classify what is a climate case or what is not a climate case. So,
thank you. Obrigado.
Obrigado.
Well, I was asking, and I don't know if you hear me better now.
Yes.
If you have any news about Belém, the meeting of the United Nations about climate change, can we expect good news, or just the same, no agreements, no consensus, no compromises? What do you say? Are you optimistic or not?
I'm not so optimistic. Not so optimistic. And that's, I think, the general view. That we can really expect too much from this summit, from COP that in Belém. It's not finished yet. Of course, a lot is still going on. I had no opportunity to be there. First, because I had a lot of other things to do, and secondly, because it was very difficult to get lodging there and to get flights there. You know that even some countries were not represented there, or even underrepresented. So I think that was a mistake. They were still working on some facilities when it began. So there was really an underestimation by our government and even the local authorities, which really dealt to, let's say, some weakening of the meeting at all. So I'm not so optimistic, but we have some, let's say, all over the world, I must say, we have some retrogression in the political environment, and in the, of course, economic environment, in terms of strong developments in environmental protection. So let's say even an example in Brazil. The Lula government, though having done a lot compared to the former government, one must say this, now is starting to exploit new oil fields in the Amazon region. So it's a contradiction. And Brazil has about 90% of renewable, of clean energies, actually. So the pressure, economic and political pressure from Petrobras and other economic actors was too high. It's too much money involved. And so they were able to pass now these researches and the possibility to start exploiting oil at the Amazon region. So, and this is the climate, this is the environment. In the Congress, for instance, Brazil, we have a big part of the Congress is very conservative, dominated by the economic actors, especially by the agribusiness. I think it's a little bit the right wing, of course, are tending more against environmental protection than the left wing. But of course, we know that during a lot of time, communist countries were responsible for a huge part of pollution. So that's not necessarily right wing is in favor of, is against environment, and left wing is in favor of environment. It's not so simple. But it's still early to say what is coming out at the end of COP in Belém. So that's what I can say at the moment.
Thank you very much. Well, I don't think there are any more questions, so I just have to thank our dear friend and colleague, Professor Ingo Sarlet. That has been, as always, a pleasure being with you. We learned a lot about this topical topic, and well, we'll count on you for further organizations. And I hope that in the next conference next week, I can be in better conditions than now, because first I had image, but I had problems with the sound. Then I got the sound solved, but I lost image. So it's really complicated, but I have to to look for another solution. So thank you very much.
Thank you
Uh,
so much. Thank you so much,
and
Vas. Thanks so much, all of
thank
you.
you. We thank you. It was a great conference. Bye, everybody. See you
Bye
next
bye.
week. Bye
Thank you
bye.
so much. Bye bye.
Thank you.
Thank you.
Thank
Ciao.
you.
See you. Bye.